My permanent residency application has been refused, but no procedural fairness letter has been issued, and therefore the officer has violated the very principle of procedural fairness and natural justice, and therefore I reserve the right to go for a reconsideration. I hear this quite often these days, and unfortunately, upon detailed review of the application and the refusal, it becomes quite clear that the officer has actually not violated the principle of natural justice and procedural fairness. Kaur versus Canada, it's a 2024 case where the federal court quite categorically said that if that application is incomplete or if that application lacks the very basic, the officer has no reason to issue you a procedural fairness letter. Okay, the officer has the right to grant you a decision, which is a refusal in this case quite directly. A case, for example, is that, for example, you did not pay an application fee and somewhat submitted that application. You did not attach your marriage certificate for your spousal sponsorship application. You did not submit your marriage certificate for, let's say, for an open work permit application. You did not provide your employment reference letter. You did not provide your pay stubs. You did not complete a form. All these are considered as a basic mistake for which a procedural fairness letter may not even be issued. Therefore, it is also important for you to understand where a procedural fairness letter is always issued. Non-disclosure of the previous visa refusals, non-disclosure of inadmissibilities, fraudulent documents, lack of genuineness in the marriage, lack of genuineness in the relationship, intention behind the marriage, etc. All these are the reasons where officer feels that you might have omitted something, you might have committed an error, you might have committed a mistake, and therefore the federal court precedents of the principle of natural justice comes into picture. A formal procedural fairness letter is being issued to you. Ideally 30 days time, or sometimes 10 days or 15 days time is given to you for you to provide a constructive submission. Long story short, IRCC reserves the right to refuse your application without issuing you a procedural fairness letter, and that may not always be considered as a violation of principle of natural justice. Therefore, before going ahead with the reconsideration, you should read Kaur versus Canada, take a legal help, and then go for it.